Hello, my name is Jens Woelk. I'm working for the Institute for Comparative Federalism, and I'm also a professor at the University of Trento. And my talk today is about individual and group rights, the balance between both, and Article 2 as Grundnorm, or you can say essential core, of the Autonomy Statute. And what is a Grundnorm? A Grundnorm, in a way, is the most important content of a legal system, of a legal provision. And here it is a concept which has been developed by Austrian legal scholar, famous legal scholar Hans Kelsen, 100 years ago. And it is basically the very provision which is at the very core of any legal system, in the sense that everything is in a way projected or derived from that norm. So it's a very pretentious concept. And here I have used this concept in order to explain Article 2 of the Autonomy Statute, which from my point of view is such a Grundnorm, such a fundamental, essential provision, and explains very well, in one sentence, what the whole system is about. And if we go and see what the text of this provision says, it says, in the region, equality of rights for all citizens is recognized, regardless of the linguistic group to which they belong. And respective ethnic and cultural characteristics shall be safeguarded. So you see, this provision has two parts. The first one is the one on equality of rights for all citizens. So it's about individual equality, and it does not matter whether you are a German speaker, Italian speaker, a Latin speaker. It does not matter what's your gender. It does not matter who's your father, who's your mother. So you are, as a person, as a human being, you are equal. And this is a very constitutional concept, which you can find in many constitutions, the principle of equality based on individual equality, so as a human being. But we also have a second part, which is very different, and which is basically addressing the collective dimension and also the conflict of the past. And this concept, the second part, is related to the collective dimension, as I said, to group rights in a way. It's a bit softer formulated. It's not talking about rights, but it says respective ethnic and cultural characteristics shall be safeguarded. So what is characteristic, what is typical for a group, in particular in our context, language and difference in language and culture, this shall not be assimilated, as it has happened in the past. During fascism, there was a policy of forced assimilation of the German speakers, but it shall be, on the contrary, recognized and also be a positive value. You can live your difference. There's the right to be different, also at a collective level. Collective, what does this mean? This means that the group as such has the right to live and to realize and to develop even this difference. For example, with a school system which takes into account that there are German speakers, Italian speakers, and Latin speakers, so that the schools are organized in a way to respect these differences and to teach issues which are more related to a German-speaking culture in the German-speaking schools and other subjects in the Italian-speaking schools related more to the Italian culture. Of course, there's also the issue of understanding each other and in particular at school, teaching the instruments which are necessary in order to do so. But coming back to our Grundnorm, so I said that it's Article 2 of the Autonomy Statute. Why it's not Article 1? Simply because, and also Article 2 starts with that, in the region, simply because in the first article of the statute, the territorial scope of application and the very region / the autonomous province of South Tyrol is established. This is the content of the first article. So basically the first article, which is open for content, is Article 2, and this is why this article summarizes the historical compromise. The historical compromise is the one which has been agreed upon in the Gruber-de Gasperi Agreement of 1946, which became then part of the peace treaty with Italy. So it's an obligation for Italy to deal with this territory in a special way. And the historical compromise, as I said, summarized in Article 2, says so. It says that citizens are equal. There are no second-class citizens anymore, as it used to be the case for the German speakers after the annexation during this forced assimilation period. So they are equal to Italian speakers and vice versa. And the second part is that we have a special area here, a region in which a different law, a different legal regulation applies in order to safeguard these collective dimension and the differences in that collective dimension. And this is the basic compromise enshrined in this Grundnorm, in this essential fundamental provision. So you see there is, on one hand, the original intention of the drafters, which is reflected, and you can compare it actually with Article 1 of the Gruber-de Gasperi Agreement, which is a bit longer but contains the same elements. But it's also the foundation of the concrete form of the autonomy system, giving guidelines for its implementation, because this is, if you want, the polar star for any question which might arise during the implementation. And it's even going further because it's also the guideline for the future evolution, because it provides the spirit and the value orientation for the future evolution of the autonomy system, which can be useful for avoiding contradictions and also for respecting the unity of such an autonomy system. And it is very common actually that in constitutions you have a kind of essential core of principles or supreme principles, and I would dare to say that this Article 2, due to this specific content, contains exactly this essential core of the autonomy system, enshrining this historical compromise. And now what is this system about? And if we go a bit further and think of how such an autonomy system is organized, then there are, I would dare to say, different levels of regulation. And you can, in the balance of the protection of rights and the rules for living together, you can distinguish these levels of regulations. And I have chosen here a distinction which proposes 4 different levels. The first one is related to the group dimension and to the question of minority rights in the strict sense and the narrow sense, and the relations between different groups. So the relations between German speakers, Italian speakers, and Latin speakers within South Tyrol. Here's, for example, the question of the system of power sharing between these groups. The question that you have autonomy for the groups in organizing their cultural sphere, in particular school. Power sharing, that you have a certain minimum guarantee for members of the provincial government, that you have a proportional quota system regarding the representation in the public administration, that you have Speaker of the Parliament who is half of the period belonging to one ethnic group and the other half to the other. So there's a rotation between these two in order to show that this provincial assembly is of both groups, but also there's a guarantee of representation. Then you have, as a second level of regulation, the external relations. The external relations, in particular, of the minority with a kin state, in this case Austria. So the German speakers in South Tyrol have the right of having relations with Austria. This is not so immediate in the autonomy statute itself, because this was very early, 1948. But we have actually from that time a treaty between Italy and Austria regarding the cross-border traffic. And then cross-border relations have increased de facto, but also in their legal recognition. And this is now a very important issue up to a European region, which is under EU law, a special regulation for institutionally cooperating with the northern land Tyrol and the southern neighbor, the autonomous province of Trento. So this is an issue which has been only very, very briefly touched upon in the autonomy statute due to the time, but has been developed and is certainly an area where also in future we might see still further development. Then the third level of regulation would be the territorial autonomy and the scope of autonomous powers. Here we find basically all the special rules which the autonomous province can adopt on its own. So autonomy in the sense I make my own rules, and these rules can be different, in part even shall be different in order to react to the specific situation on the ground, different from the one in the rest of Italy or other Italian regions. And I have the right to be different, and this is linked to the exercise of competencies which are enshrined in the autonomy statute itself. The autonomy statute as a constitutional law, and so we have a list of competences which are basically complementary and in part even more important than the competences which are listed for all other regions in the Italian constitution. So this is the territorial dimension and the dimension of territorial autonomy. And these rules, of course, do not have validity elsewhere. They are only in force for the territory of South Tyrol or sometimes for the region. Then we have the fourth dimension, which is a very important one, and in a way you can say it's the flip side of what I just said regarding autonomy. It's the question of integration, the integration of the autonomy system into the state. So how can this autonomy be reconciled with being part of a bigger system, which is the Republic of Italy? And how can it be reconciled nowadays with being part of an even bigger system, which is the European Union? And how can this reconciliation be done without violating at the same time the autonomous powers? So how can a meaningful autonomy be exercised in a wider system? This is the question. And this means that you need to be consulted. If Italy wants to, for example, adopt an economic reform for the whole country, which should also apply in South Tyrol, then there is the need of coordinating this, and it depends on the competencies, it depends on cooperation procedures and coordination procedures, how this is done in detail. But this is the question. Does this also apply, and is there room for discretion in order to adapt this? So these are mechanisms which could be applied. So this is this area. How does this autonomy system fit into the wider environment? And last but not least, these four different areas of regulation are then declined also subject to two different principles, which we can see, and I think this is an important distinction which is useful to have in mind when looking at single provisions. There are provisions which are more governed or even exclusively governed by the personal principle, and there are others which are instead governed by a kind of entity-related principle, which is called the territorial principle. So personal and territorial principle. What do I mean? Minority rights are typically related to a personal principle because the majority does not need them. But if you are a member of a minority, or in this case, if you're a member of a linguistic group, then you can, for example, choose in the in the court system, you can choose, or your lawyer can choose for you, which is the language of the trial and how is which is the language in the court which is mainly used. But the fact that this is possible, that you can distinguish and you can choose, this is again linked to the territorial principle, because the court system in South Tyrol is organized in a way that both languages, Italian and German, are possible choices, are possible options. And so you need bilingual judges, you need bilingual stuff, you need translating stuff, you need a database, for example, which adapts German legal terminology, because the legal German used in Germany or in Austria does not fit for the Italian legal system. So there is a whole range of issues you need in terms of organization, and which are linked to the territorial autonomy, because they are applied only in this part of Italy, not in the rest of Italy. But then the question, which language you actually use, depends on your own personal choice, and this is related to the personal principle. Another example would be the school system. You organize the school system in a way that there are Italian-speaking schools, German-speaking schools, and schools in the Latin valleys, and they have different organizations, as I said before. But and this is territorial principle. It's also group-related, because the group has the right to organize then within the territorial frame the single type of schools. So it's a kind of self-administration of the school. But there's also personal rights in the way that the individual has the right to choose the school he or she wants to go to. Of course, knowing the language, being able to follow the language at this school. Territorial principle, what is important here is that there are a lot of different rules compared to the rest of Italy, related, for example, to planning, which is very important because it's related to the use of territory. Where can you build a mall? Can you build a mall at all? It's related to the infrastructure and to the roads. For example, the policy of building, investing in good roads that people can stay in the mountains and work half day in the valleys. This could be an official policy which is done here, but not so in the rest of Italy. You can organize, linked to that, local transport in a special way, because this is your competence. The question of commerce, of shops. I already mentioned the malls. There are the question of maybe different opening hours compared to the rest of Italy, or when sale starts, and these are very common issues. So these are linked to the territorial principle, because these are choices you can do, and you can do differently due to your territorial autonomy, but which also only apply here.